Good afternoon. We're going to go ahead and get started. My name is Aaron Wallace. I'm a senior editor of the South Texas Law Review, and it's my pleasure to introduce Professor Blackman. Professor Blackman is Associate Professor of Law at South Texas College of Law in Houston. South Texas College of Law, Houston, sorry. Make sure I say that right.
You might get sued.
Right. Specializes in constitutional law, United States Supreme Court, and the intersection of law and technology. Professor Blackman is the author of the critically acclaimed Unprecedented Constitutional Challenge to Obamacare for 2013 and Unraveled Obamacare, Religious Liberty, and Executive Power from Cambridge University Press in 2016. Please join me in welcoming Professor Blackman.
Thank you so much. It's a pleasure to be here. This symposium is the result of a lot of hard work by many students. I'm grateful for all the speakers who came here from around the globe, indeed. I am back in cleanup, so the last and most certainly least, and I will tell you things you probably already know. The Foreign Emolument Clause provides that no person holding the office of profit or trust under the United States shall, without the consent of Congress, accept of any present emolument, office or title of any kind, whatever, from any king, prince, or foreign state. We've had people talk about the emolument clause and the president, how to understand it. I'm going to focus on a couple words there. Holding any office of profit or trust under the United States. Some people contend that the president holds an office of profit or trust under the United States. This argument certainly has an intuitive appeal, right? This argument certainly has an intuitive appeal. How could the president be exempted from this important anti-corruption principle? But an intuition is not an argument. No Article III court has ever held that the language in the Foreign Emoluments Clause, or any similar language in any other provision of the Constitution, applies to the president. Moreover, this intuition must be tempered by the text of the entire Constitution. And for students of mine, you recognize, always carry your Constitution. Indeed, the other side can only ignore our great charter. The framers of the Constitution, making use of a long-standing drafting convention, used the phrase office under the United States to refer to appointed officials in all three branches of government. That category did not include elected officials such as the president or members of Congress. The overwhelming weight of evidence stretching from the American Revolution to the Constitutional Convention to the first Congress to the Washington administration and into the early Republic demonstrates that elected officials such as the president do not hold an office of profit or trust under the United States. Thus, the president is not bound by the Foreign Emoluments Clause. Now, as Seth mentioned earlier, there are various streams of authority. And there's certainly a stream of authority for the proposition that some antebellum presidents, starting no earlier than Jackson, asked for Congress to dispose of foreign gifts. And from the stream of authority, some have said that this is evidence that the president is bound by the clause. Now, we, as Seth or Marlots, I can't remember, but whatever we are, we recognize there are these different streams, but we seek to reconcile them. So, to give you a preview, the antebellum presidents, the evidence is problematic because none of them actually asked to keep the gifts. They just asked Congress to dispose of the gifts. Moreover, these presidents held office 4 decades after the ratification. This evidence is far less probative than the practices of President Washington and his successors in the early republic, who openly received, accepted, and kept diplomatic gifts and other gifts from foreign governments without seeking congressional consent. And when we're faced with these different streams of authority, right, you might call it original defiance and later acquiescence. Original defiance wins any time. That is, if a founding president is openly violating what you say is a rule, and later presidents are tacitly surrendering to that rule, original defiance prevails. So I agree, and Seth agrees, that the president's business activities are less than ideal. I wish he could have these businesses. But they're not unconstitutional. That's the important point to stress. So our story begins with President Washington, as any good story should. I think Seth alluded to this earlier today. In 1791, Washington received, accepted, and kept a diplomatic gift. It was a framed, full-length portrait of King Louis XVI before he lost his upper extremities, from Jean-Baptiste Chevalier de Trinant, the French ambassador to the United States. There's no evidence that Washington ever sought or received congressional consent to keep this valuable gift. Indeed, Congress would have no occasion to even consider the propriety of the diplomat.
Seth will be happy to talk, I'm sure.
Congress never considered this aspect of diplomatic gift till 1798. Oh, I'm losing my voice. God's going to pop something for the Louis speech. In addition to the portrait, Washington also received a key to the Bastille, along with a picture of the Marquis de Lafayette, who at the time was a French government official. Both of these items were prominently displayed in the federal capitol. The portrait and the valuable ornate frame were prominently displayed with the Washington crest and a monogram of the French king. It hung in Washington's principal room. The key was on display in Washington's first home in New York City at number 3 Cherry Street, and was showcased in Philadelphia when the seat of government moved there in 1790. Their foreign provenance would have been immediately recognizable to anyone who saw them, yet there is no evidence that cabinet members who walked past both items and would generally advise the president on constitutional matters reported any dissent. Nor did any anti-administration members of Congress or the press raise any hackles. Indeed, the provenance of the key was widely reported in contemporaneous newspapers. Those who argue these were secret gifts don't have an argument. But the important point to stress here is that we should not start from the presumption that George Washington was a lawbreaker. He was our archetypal president. He set all of the early practices of the executive. And if your argument is that George Washington was a crook, again, as Seth said, I give you courage, but you're wrong. Washington was not alone. President Jefferson also accepted diplomatic gifts without seeking congressional consent. In 1804, President Jefferson received a diplomatic gift from the Russian government. It was a bust of Emperor, or Tsar, Alexander I. Jefferson received, accepted, and kept this diplomatic gift. Indeed, Jefferson wrote that his particular esteem for Alexander convinced him to break his personal rule of not accepting gifts while in public office. There is no indication Jefferson felt his decision was controlled by the Foreign Emoluments Clause. Rather, this was a decision governed by his own conscience. Like with Washington, there is no evidence Jefferson ever sought or received congressional consent to keep the bust. Jefferson also received presents from foreign Indian nations, which he considered diplomatic gifts. During their Great Trek, Lewis and Clark exchanged many gifts with Indian tribes in diplomatic and social contexts. Lewis delivered these gifts to Jefferson, who viewed them as coming from foreign nations. Jefferson never sought congressional consent, and they are still on display at Monticello to this day. So Jefferson's practice of accepting gifts from foreign nations without seeking Congress's consent provides further support in regard to the meaning of the Foreign Emoluments Clause. Indeed, it's maybe even more revealing than Washington's, because some may argue that Washington was friends with Lafayette. But Jefferson kept gifts from the Tsar, whom he'd never met, and Indian leaders who he had no relationship with. Okay? And unlike Washington, who was pretty popular, Jefferson had fierce political adversaries who could have attacked him for foreign corruption. Oh, and they attacked him for foreign corruption in other contexts. What all these foreign government presidents had in common was that the president and recipients believed, as best as we can tell, that their keeping the presidents had zero constitutional implications. We don't stop at Jefferson. Presidents Madison and Monroe accepted a diplomatic gift without requesting congressional consent. In 1816, General Ignacio Alvarez, who was a South American revolutionary head of government, sent to James Madison 2 pistols to form a closer connection with the United States. The pistols were given to to Madison through diplomatic channels. The pistols today, we admit, cannot be found. And the reason why they can't be found, the story goes, is that Madison gave them to his successor, James Monroe, all absent congressional consent. So if it's the case that the president is bound by the Foreign Emoluments Clause, not only did James Madison, the most significant framer we have, wrongfully convert government property, but James Monroe, another prominent founder, connived with his predecessor to receive what amounts to stolen government property. I like history. I have a very hard time labeling the first 5 presidents, or 4 of the first 5 presidents crooks. I'm hesitant to do that. But the second point I want to make is this. The evidence from the earlier administrations are superior to those in later presidencies. And let me give you a hypothetical. And I used this in a brief I wrote for the Southern District of New York, but it works in Texas just the same. Consider a hypothetical, right? The year is 1920. How do you handle vacation time? So at the time, Judge Learned Hand was a famous judge, and his law clerks were involved in drafting the rule. This was a rule drafted 100 years ago. Today, there's a debate about whether this provision covers law clerks in addition to employees of the clerk's office. Again, it said all clerk employees. Is that a law clerk or people in the clerk's office? And there are 2 streams of okay, the first stream. Throughout the 1920s, law clerks never requested vacation time. They just took off when they wanted. And there was no negative repercussions, even from Judge Learned Hand himself. Second, after World War II, as institutional memory faded, both types of employees began requesting vacation time in advance. So which authority is better, right? The defiance closer to the rules drafting, or surrender, acquiescence later in time? Under the latter view, the surrender view, today's law clerks are out of luck because you're giving too much credence to voluntary compliance by actors distant from the rules drafting. Under the defiance view, law clerks are good, right? Because you give more weight to when someone had a hand, no pun intended, in drafting the rule and violated it with impunity, with no repercussions. Courts generally follow the defiance rule, right? In a separation of powers, you look first in time to where there is a conflict. And I think this provides the rule of decision of how to understand. Do we go with Washington, Jefferson, Madison, Monroe? Or do we go with Andrew Jackson, a president who threw judges in jail and is not exactly remembered as a solid president? His statue probably comes down soon now, right? Yeah, we'll take down Jackson's perhaps, or maybe not. So let's talk then about the Antebellum Presidents. You have Jackson, Van Buren, Tyler, and maybe Lincoln also. The important point to stress is that all of these presidents received gifts from foreign nations. But if you actually read the congressional record, which I've done, and perhaps the other side hasn't, but if you read the congressional record, they've all asked Congress to dispose of the gifts. None of them asked to keep it. So President Jackson said, quote, "I placed the medals at the disposal of Congress." He wasn't keeping it for himself. Van Buren wrote, "I deem it my duty to lay the proposition before Congress for such disposition as they may think fit to make of it." Again, he was giving away to Congress. He didn't want it. A lot of these gifts were very impractical. Like one of them was like a bunch of Arabian horses, right? Where the heck do you keep Arabian horses in Washington, D.C.? They didn't want it. Get rid of it. Okay? We now have President Tyler, right? Tyler wrote that the foreign gifts will be disposed of in such a manner as Congress may think proper to direct. There was another gift where Lincoln received these swords and tusks from the King of Siam. And he said these should be deposited in a collection of curiosities at the Department of the Interior. Okay? The Lincoln gift, though, there's another one that's a little more interesting. I want to dive into this one for a bit. In 1860, the Republic of San Marino, which is this little place near Italy, voted to confer honorary citizenship on James Buchanan, who at the time was the president. There's no record Buchanan ever responded to this gift of citizenship. But in May of 1861, after the election, and indeed in the midst of the Civil War, Lincoln thanked the Council of San Marino for the gift. He deposited it with the Department of State, but never sought congressional consent. Because the citizenship was conferred before the election, I think the best reading, and the Office of Legal Counsel agrees, is that this was a gift to the United States and not a personal gift, because Buchanan was no longer the president. It was a gift of citizenship. It can't be transferred. There was the other gift I mentioned from Siam, where again, the King of Siam sent President Buchanan a sword and a photograph. There's no record and acknowledged the letter before he left office. 1 year later, Lincoln replied, thanking the king for the sword and the photograph, as well as the tusks. However, Lincoln never actually sought Congress's consent to accept the gifts, as the Foreign Emolument Clause requires. Rather, he merely deposited it with the Department of the Interior. Perhaps Lincoln thought, like the diploma, that the gifts sent to his predecessor were best viewed as belonging to the United States, and no consent was needed. In any event, Congress was aware of the difference between accepting gifts and merely depositing lawfully received gifts with the government. In 1856, for example, Congress consented to the receipt of a gold medal given to the superintendent of the Coast Survey from the King of Sweden. So Congress knows how to accept foreign gifts. They know how to vote on it. It was never done by Jackson, by Van Buren, by Tyler, or even by Lincoln. In fact, the Office of Legal Counsel said it could only identify one instance, where Congress gave a grant of consent to a president where it followed receipt of a foreign gift. In an 1896 joint resolution, Congress authorized Benjamin Harrison, the president, to accept medals presented to him by the governments of Brazil and Spain. That's all, folks. That's it. You have a single act where a president in 1896, over a century after the ratification, asked Congress if he could take some medals. This single voluntary acquiescence, over 100 years after ratification, cannot outweigh the weighty precedents set by Washington, Jefferson, Madison, and Monroe. Indeed, this request for permission from Harrison represents a sharp break. There's no indication Harrison knew about the practices of Washington. In fact, I think until Professor Tillman wrote about this, no one knew about this. These are things that faded into oblivion, which is why we need clean, pure, sometimes annoying thinkers like Tillman to carp us and nudge us to revisit our priors. The court might simply take that intuitive position that, they're all presidents, and all presidents have equal authority. So the later presidents ought to be preferred. But courts don't act this way. Earlier authority is better, and defiance beats acquiescence. Now you can say, wait a minute, Josh, how are we looking to Washington and Madison and Monroe? It's after ratification. Doesn't originalism say we look at the meaning in 1789 and stop there? How are we looking to practice, right? What role does practice play in originalism? So we have an opinion on point, which is District of Columbia v. Heller. In order to interpret the Second Amendment, Justice Scalia's majority opinion looked not only to pre-ratification sources, but also from precedents after the Bill of Rights was ratified. In dissent, Justice Stevens found particularly puzzling the majority's reliance on post-enactment commentary, right? How we rely on this post-enactment legislative history, as Stevens said. To this, Justice Scalia countered the of a legal text in the period after its enactment or ratification is a, quote, critical tool of constitutional interpretation. We don't speak today about emoluments, right? It's a word that just doesn't have much resonance today. Today, if you're saying office of the United States, office under the United States, most scholars assume they're the same thing. They assume they have no significant differences. But that was not the case at the time of the ratification. These were words with meaning, and the framers used them deliberately and repeatedly to mean different things. And for us to understand what these words mean, it's not only appropriate, it's necessary to look at how these early figures understood the Constitution. But not all post-enactment commentary is of equal weight. As time lapses from the framing, Justice Scalia observed, the latter sources do not provide, quote, as much insight. The most reliable sources are those most proximal to the founding. Post-enactment commentary is useful, if at all, where it confirms earlier understandings. These antebellum presidents don't confirm the earlier understandings. They conflict with it. And they conflict, again, in an odd way. They do not show defiance, they show a voluntary surrender of power. One president that voluntarily surrenders his power cannot bind his successors. See Free Enterprise Fund versus Peekaboo. So at bottom, isolated contrary practices, they don't establish a long-settled precedent, and they should not prevail over a founding president. Right? Why? Because purported defiance by Washington is more probative than voluntary surrender by Jackson. So this is moving away from emoluments and moving to a topic that's a favorite of mine, where I'm much more comfortable talking about, which is the separation of powers. In our separation of powers, where one branch of the government takes an action of doubtful constitutionality, and in doing so, arguably invades the constitutional sphere of another branch. If the latter acquiesces, such acquiescence or pushback to be expected ratifies the propriety of that contested action. On the other hand, where a branch of the federal government takes an action of dubious constitutionality, and in doing so surrenders its own arguable powers, such self-abnegation is accorded little weight, because surrender occasions no public discussion or pushback from the other branches. And I'll give you a few cases, which you're no doubt familiar with. In the famous steel seizure case, Youngstown Tube Company versus Sawyer, President Truman took over the steel mills. And there was a question of whether the executive branch had the authority to seize private property. Congress, in that case, was a little bit lazy, right? Truman seized the mills, sent a note to Congress saying, hey, Congress, look what I did. You want to do something about it? My students remember. What did Congress do? Nothing. So in Youngstown, the court noted that Congress took no action after Truman's communication, right? We looked to see whether branches defied or perhaps surrendered. Another case, a famous case in the separation of powers, called Baines and Moore versus Reagan. This involved the aftermath of the Iran hostage crisis, where after all the hostages were freed, the United States government reached a resolution to suspend any lawsuits by U.S. citizens against Iranian government officials. After President Reagan took this action, which I don't think he had the authority to do, but did Congress say anything? No. And in fact, Justice Rehnquist's opinion wrote, we are thus clearly not confronted with a situation in which Congress has in some way resisted the exercise of presidential authority. So where one branch doesn't resist the other branch, right? That's acquiescence. Another case that teaches the opposite lesson is Clinton versus City of New York. This is a case involving the line item veto, where Congress actually voted for a bill which allowed the president to strike out provisions of funding packages. Congress surrendered its own power. And read Justice Kennedy's concurring opinion. He said, it is no answer, of course, to say that Congress surrendered its authority by its own hand. Abdication of responsibility is not part of the constitutional design. So even if Jackson and Van Buren and Tyler surrendered this power, they said, okay, you know what? We're not bound by the Foreign Emoluments Clause, but pretend to be. That doesn't affect Trump. One president can't find the next. Here's the quote from Free Enterprise Fund versus PCAOB. Peekaboo, if you're cool. Chief Justice Roberts explained, perhaps an individual president might find advantages in tying his own hands. But the separation of powers does not depend on the views of individual presidents, nor on whether the encroached upon branch approves the encroachment. The president can always choose to restrain himself from dealing with his subordinates. He cannot, however, choose to bind successors by diminishing their powers, nor can he escape responsibility for his choices by pretending they are not his own. Okay. So the lesson I think we learned from the separation of powers framework is when these later presidents, poorly, and I don't think they did, but let's take they're right, when these later presidents pretended to be bound by the Foreign Emoluments Clause, that is of far less weight than when earlier presidents purportedly defied it. Okay? When Washington and the other early presidents received diplomatic gifts, if that conduct was arguably unconstitutional, it wasn't, but if it was arguably unconstitutional, if it invaded Congress's authority to consent to such gifts under the Foreign Emoluments Clause, then one would expect someone in the public to object. If there was no contemporaneous objection, then that ratifies the contested conduct. If the benefits from Washington transactions were these foreign emoluments, then it trespassed on Congress's powers. The absence of congressional debate or public debate of the president's conduct ratifies the president's position. On the other hand, when Jackson and post-Jackson presidents surrender their arguable power to receive diplomatic gifts after congressional consent, such a surrender, or even a long-standing modern pedigree of surrender, counts for something, but such surrender counts for a good deal less. Distant post-ratification surrender, starting half a century after the Constitution's ratification, and done in ignorance of the original practice of the government, is far less probative than purported open defiance by Washington, Jefferson, Madison, and Monroe. Thomas Jefferson explained, one precedent in favor of power is stronger than 100 against it. Now, I want to close my remarks. How much time do I have left? 15 minutes, okay. So I want to close my remarks today by giving a high-level perspective of the current litigation, as well as much of my general response to the Trump presidency. Seth mentioned some of the fire I've been taking recently, which I'm largely impervious to. I don't like responding to people who think they're not worth my time. I mean that sincerely. I'll respond in forms that actually count. But before the election, I signed a letter called Originalists Against Trump. And this was a statement against interest. I probably could have leveraged the election to great personal gain, but I came out as a matter of principle opposing candidate Trump because I thought he was dangerous. I still do think he is. Yet, consistently since the election, I've been struck by how so many reasonable people are making arguments that aren't very reasonable. And they're weaponizing constitutional clauses that have never been understood in this fashion. And they're taking long-standing doctrine involving national security and equal protection clause and animus and all these other things and using them in ways that are stunning. And I'm so glad you heard Jane earlier today, and I've actually learned a lot from her work over the past 6 or 7 months about how courts should respond to this norm-busting president. And there's this concept of the presumption of regularity. And Jane discussed it far better than I will today. To stress is the entire notion of this presumption of regularity is premised on the fact that the courts are the least dangerous branch, as Hamilton called them. And when judges decide that all of a sudden we have this dangerous president who requires special treatment, like you tell a kid to go sit in the corner if he misbehaves, right? That may sound great when you agree with the policies, and I agree with almost none of Trump's policies. The travel ban's an awful idea. I think he should dissolve all of his businesses. I didn't vote for him. I lost. Okay, move on. But when courts start adjusting their screens of deference, when the circumstances so indicate, there's a risk, because power that's once aggrandized is seldom relinquished, right? Once a branch of government gets some power, they very rarely give it up. The courts have a very unique role in our constitutional order. Generally, changes are slow, not fast. Or, for my property students, accretion and not fill the blank. Oh, one of you, please. Accretion, not avulsion. Thank you. Good. This is my property students listen. Accretion, not avulsion. Courts percolate. They think. They digest. The courts with Trump have been on crack, right? In the span of a week, they threw all caution to us, oh my God, we got to do something, right? Now, if there's a disaster, we had Harvey last week, and Houstonians came together and they said we have to respond to this emergency. And they did amazing things. The Cajun Navy rolled down Main Street, right? And is rescuing people. The judges aren't here to rescue us in that sort of rapid fashion. I know they like to think of themselves as such. Life tenure does that to a person. But that's not their job. That's not what they were sworn to do. And if any court is going to announce a judicial coup, let it be Anthony Kennedy, and not some district judge never heard of. So the big difference, right, it's often said that, well, this is, the courts need to respond to Trump the same way they responded to Jim Crow. This is an institutional crisis. I think that argument fails for a couple of reasons, right? First off, Jim Crow was an institution that corrupted our republic for a century. That was an awful, awful scourge in our republic. Donald Trump has been president for about 7 months. Not very popular. His own party's abandoning him. May not make it to a second term as a Republican. So I think the courts jumped the gun. Second, if you look at a decision like Brown, which is this monumental opus, right, where the courts stood up to segregation, that didn't come overnight, right? It wasn't like a week after the inauguration of Dwight Eisenhower that, okay, we're going to do this, desegregation. It had been building up for decades as the court chipped away at Plessy versus Ferguson. Yet, not even a week after the inauguration, courts engaged in this act of judicial self-help, right? They struck down the travel ban. There was no percolation. It was like, oh my God, this is different, we gotta stop it. And I get the reflex, right? I get why judges are doing that. I'm often hard on them. Maybe I shouldn't be, I don't know. But I see my lonely job as saying, stop, right? If you read the very first issue of National Review, William F. Buckley said the job of conservative is if you're standing and looking at a train running up the rails and saying, stop, right? You may not be able to stop the train, but at least you can warn them that maybe they should slow down a bit. You can pick up the gas. And I made one point, I say bring up time, but I made one more point. Some people may argue that it's a good thing that courts are unsettling constitutional law. These changes, though, they're not small, they're huge. Because power amassed is seldom surrendered. Maybe this Burkean conservative gives me cause before jettisoning our current constitutional settled order. But I prefer the evil I know to the one that I don't know. I don't particularly like our court system, but I know them. I'm familiar with it. I am much more afraid of what a post-Trumpified judiciary looks like. I know what it looks like. None of you do either. And again, my job here is to say stop. Thank you so much, and I welcome your questions. Yes, sir. Mr. Phillips.
So there's the debate amongst original scholars right now on the concept of original expected applications, right? So the classic example that's put forward for this is the text of the 14th Amendment, where you have persons is used, and that's broad language, right? It doesn't limit itself to freed slaves or people who are African American, and it's unclear that, at least some people would argue, it's unclear that the ratifiers and the framers of the 14th Amendment quite understood the scope of maybe what they put into words. So I guess I just wanted you to respond to that in the context of what do we do if we have an instance where it seems like the words that they made the law and their early practice, which would, you know, the argument is reflect their understanding, if there's tension.
Okay, a very good question from James. I'll answer it this way. Some of you in this room may remember the Equal Rights Amendment. Sally, you remember that? Did it get ratified? No. So in the 1970s, there was a movement to actually amend the Constitution to add an amendment to expressly guarantee protections for gender equality. That's what it would have done. And due to the efforts of Phyllis Schlafly and others, that did not go far. It got enough states. I think it was maybe 2 or 3 states short. I might be off my math. I think it got maybe within 2 or 3 states. And it was it Sherry, is it 2? Thank you. I knew I was close. Thank you. You got. See, having a CIVRA professor and a Constitution expert, we are so lucky at South Texas. But there was an opinion by Justice Powell. I think it was Powell. I can't remember if it was Frontiero or the other ones. He said, you know, the plaintiffs asked us to expand heightened scrutiny to gender equality. And he's like, I'm not ready to do that yet, because there's an amendment ratifying in the background. But he wasn't in the majority. The court said we give intermediate scrutiny for gender equality. So I always give my students this counterfactual, right? What if 2 more states had ratified? 3 more states had ratified? We'd have a 27th Amendment on the books. And then we have 28 now. We'd have 27 amendments in the books. And then the courts could cite a specific textual clause saying we do give meaningful judicial review to classifications on the basis of gender. And then we wouldn't have a debate. It'd be there, and it'd be from the people themselves. But because the Supreme Court shortcutted that process, we never got there. So the originalist in me, and there's a pretty strong one, is always hesitant to try to make the Constitution fit the world we live in. The Constitution was drafted for a very different time. The Commerce Clause was not designed to bear the administrative state that we have. It simply wasn't. You can't plausibly read it that way. So, by updating the Constitution through judicial decision rather than through amendment, we shortcut the process. There's a quote, I think it was by Rexford Tugwell, who was a member of the New Deal cabinet, one of FDR's New Dealers. And at the time, FDR was debating, do we try to hack the court? Do we try to amend the Constitution? How do we get forward our New Deal agenda? And FDR made a decision, which was probably reasonable, saying it'd be too hard to get the states to ratify a commerce amendment, right? Who the hell wants to give the federal government this power? So let's just add some more judges, which was the New Deal plan, like the court packing scheme. But this guy, Rexford Tugwell, said we had to torture the Constitution to get there. Now, we accept it today, we have a global society, whatever. But I see my role gets always increasing lonely, saying maybe it could have done differently, maybe it could have done better. If we still respect the Constitution, which is, again, small to fit my pocket, then if we had an Equal Rights Amendment, then we wouldn't need Frontiero and Richardson and Viamont. We've had an actual amendment to prove that. But that process was cut short. And James's question about original expected application, that's an even tighter when we get to dealing with slaves, right? It says all persons, so I'm okay with all persons. And it doesn't say about men or women, okay, so I'm okay with that. But if you have an amendment that specifically mentions something, that's a good thing to have. I hope, I tell my students every year, that you live through a constitutional amendment. I hope you do. I think a good one to start would be to eliminate the ban on natural born citizens. Let anyone be present. I think that'd be a good amendment and could actually get 3/4 of the states. Andy's shaking his head no, Sally's shaking her head yes. So I don't know. But I don't pick anyone. I would love as just an experiment in government to actually have this polity go through the amendment process all the way. I think that'd be a very worthwhile task. Okay, other questions? Yes?
I was just wondering, I guess, if you could explain more how, I don't see the analogy between gifts such as paintings or medals or horses and the consequences of far-reaching, huge business empires.
Of course. And this was a question I made to Phillips earlier today. But the Foreign Emoluments Clause applies to a lot of different things. Let me read it to you. It says, okay, no person holding the office of profit or trust shall, at the consent of Congress, blah, blah, except of any present emolument, office, or title of any kind, whatever. And I think that of any kind, whatever, is pretty darn broad. I think that means things of value, right? It's a pretty broad idea. The gold frame, and then I have a picture of it. This is a very valuable gold frame. That was a thing of value. It was a present, and it's expressly in the Constitution. But I think your question is actually intuitive, right? How can we possibly compare some pistols, some Indian trinkets, a portrait of Washington, a bronze key to the Bastille, to Donald Trump's global empire, right? And I think that question, again, is trying to fit the Constitution to the world we live in today. The Constitution is open-ended. It refers to things of value. It doesn't specify a minimum dollar, right? Zipro, right? This is not $75,000 in a penny, right? We do not have a minimum, I love Jerry. We don't have a minimum amount of controversy in our Constitution. It's anything of any kind, right? So, you're right. Washington did not. Although Washington was a planter, and they sure as heck had trades. Madison shipped tobacco overseas, so they actually did have business transactions. There were no five-star hotels back in the day. Andy?
I think maybe your question could have been different. Is why are you talking about presidents and emoluments? I think the point is that the clause doesn't apply at all to the president because he took a whole bunch of presidents. So the threshold question, I think, your historical research is showing that the clause doesn't apply at all. It doesn't apply to presidents, emoluments, titles, and
Yeah, I think, but there is evidence that lower executive officials did seek consent, right? Members of the Coast Guard, members of the executive branch, diplomats, they did go to Congress to seek consent.
not Jefferson.
Jefferson was a president, he didn't need to.
40 He was a scoundrel before that.
He was a scoundrel. Any other questions?
I'll ask one.
Yes, please, Nevada.
So we've been talking generally all day about how Trump's businesses are an issue here, but can you sort of give us a background on those 3 cases you mentioned this morning that have actually been filed?
Oh, yeah, I'll try, and unlike Seth, I'll be a little more circumspect. There have been 3 lawsuits filed concerning the Foreign Emoluments Clause. One of them is Crew, which was the Council for Responsibility and Ethics in Washington, versus Trump. That was filed in the Southern District of New York. Zephyr Teachout was counsel for Crew, which she wisely did comment on it. The second case is called Blumenthal et al. v. Trump. There you had, I think, 200-something members of Congress sue the president in the District Court of Columbia, again alleging foreign emoluments. And there's a third case, the District of Columbia in Maryland, as states have sued the president. I am attorney for Seth Barrett-Tillman, as you well know by this point. And I filed a brief on his behalf in the Southern District of New York. Stay tuned for the other ones.
So are there more specific facts that are at issue?
The allegations are probably what you've read in the news, that Trump's businesses are profiting him, that you have diplomats staying at his hotel, that you have, foreign businesses renting space out in Trump Tower. The litany goes on. He's received copyrights, trademarks, and patents from the Chinese government. They're long on facts of salacious allegations. The law section, though, is a little bit smaller. I appreciate the question. Anything else? All right, so what we're doing now is me, Seth, and Jane. We'll have a little discussion. Andy, if you want to come up and moderate a bit. And I thank you for your attention. Thank you so much.
I can't rely on students to bring it.
Oh, I see that.
I want to make sure people spell it right.
Oh, he's over here. I'll do fine with Jane. Thank you. Yeah. Oh, we all hear that.
Yep. All right. Before we hop into the panel, a couple things. Josh had mentioned that it'd be great for you all to live, all of us, to live through an amendment process. That 1810 amendment that would apply the Foreign Emoluments Clause to everybody, all citizens, still pending. Proposed in 1810, was never withdrawn. We're 26 states short. If 26 states did ratify it, Congress could, I suppose, on its own say that the time has expired. But technically, you can drive to Austin and tell your legislators to ratify it. It's up to you. It's actually kind of interesting. We don't have to wonder why that amendment hasn't been ratified, because just ask yourselves, why do you not want it ratified? So you're part of that history. Second, on this discourse point, I started out my talk today, I mentioned the decline in the quality of discourse on these issues. I'll emphasize again that Seth's article and Zephyr's article presented two sides of an issue in a scholarly way before anybody could have imagined that Donald Trump would be president. And if you were to play politics, and I don't think either of them were, Zephyr or Seth, I don't even know what Seth's politics are, Zephyr at least is openly Democrat, ran as a congressional seat. But in that position, during that time, Barack Obama was president. She was not trying to screw over Trump in any way by saying that Obama would be subject to the clause. And ditto for Seth, I can't gather any politics.
I read the Congressman, so.
Oh, you did?
I didn't know that.
There's a lot about you, don't know, Josh.
Well, I did not read his work. And I hope that on these issues you can't...
I was applying to law school, that's why I did it.
That makes perfect sense. In any event, I hope that you gather from Zephyr's, Jane's, Sarah's, Josh's, everyone's talks today that this is actually a very rich issue, and it's not just you hate Trump or you love Trump. Like Blackman, I was no Trump supporter. I'm no fan of Hillary, but I voted for her. So this is not just anything that Trump does is great. Anything that he does is horrible. And I share Josh's concerns regarding the discourse, where apparently anything you don't like today is just obstruction of justice. It's really unfortunate how many people talk about that without even looking at the statutory elements. I suppose my first question for the panel relates to something that Jane and Josh each spoke about. Oh, and also, lastly, I should compliment Jane, especially for coming here. However popular your ideas might be in Washington, D.C., you joined a panel in which I think we're all live presenters probably took a different view. So that's very admirable, and it's great to see someone actually come in and debate both sides. We don't see it enough these days. So thank you very much. On this presumption of regularity point, Jane, you had mentioned, and I guess I'll ask both you and Josh for your comments on this, whether, let's just focus on the financial conflicts and maybe Trump's brazen attitudes towards the media, and let's think about, I'm curious, your thoughts on whether it really potentially upsets our constitutional structure. I'm going to read George Washington's thoughts on the media for you first. So, some of the newspapers of the United States have teemed with all the invective that disappointment, ignorance of facts, and malicious falsehoods could invent to misrepresent my politics and affections, to wound my reputation and feelings, and to weaken your confidence in me, you the people of the United States. Fake news, right? So Washington hated the media or held them in low regard. With respect to his business interests, put aside whether a diplomat bought wheat from his Mount Vernon, without a doubt, major conflicts of interest. He was rumored to be the richest man in the country, and he was probably wrong. He surely was. He died with $500 million. He served as general of the Continental Army for free. Without a doubt, he had slaves, landownings. Seth has described the various dealings he's had with the government. He purchased lands at public auctions from commissioners he appointed. He signed a patent application and licensed it from the holder on his overseas wheat business with gangbusters. So there was plenty of conflicts of interest. We may have believed that he handled them better or not, but without a doubt there were plenty of conflicts of interest, and we had a president who apparently had low regard for the media. So my question for Jane and Josh is it the case that just because a president, I suppose this is true for all presidents, just because you don't necessarily know whether he or she is acting for his own pocketbook or is for the interest of the country, does that upset the presumption of regularity, or is that just endemic to the process or to the office? I mean, there's a reason, I think, that, except for some occasional historical blips, ethics statutes don't apply to the president. It's not believed that the president is always the same. It has to do with the nature of the office and the inevitable conflicts. Jane, any thoughts on that?
So my initial comment on that is the presumption of regularity too often is invoked as though it exists in a vacuum. The question has to be, what lies beneath the presumption of regularity? Under what circumstances is it not only rebuttable, but does it not even apply? And I think the Supreme Court does offer some evidence of circumstances in which you don't even get the presumption. And that's really the very modest point that I make. That if you look at Supreme Court case law, there are circumstances in which judicial decision makers or officers of the executive branch or defense counsel are simply not entitled to the presumption of regularity because circumstances are such that they suffer a conflict of interest.
Yeah, and I have to commend Jane. We don't actually disagree on that much. I think if we have a Venn diagram, we mostly overlap. Might be a little here, a little there, we overlap. My perspective on the presumption of regularity is premised mostly on the fact that courts don't always know when to dial it on or off. That is, the standard for perhaps a misbehaving prosecutor or misbehaving defense attorney is reducible to somewhat decent standards, right? If the prosecutor accepts a bribe. But the president's office is so unique in our constitutional order. He's the only official elected by the entire populace. The VP is always basically a worthless office. Bucket of spit, as Garner said, right? The president has this unique authority, this unitary status. And I do think, better or worse, we voted for him. Yeah, I don't want to talk about Russia. If we bring up Russia, I'm not going to talk about it. Hacking, I don't want to talk about it. But he got the electoral votes. And with it comes 4 years of power, short of impeachment. Congress can hobble him in many ways. I think they may. But I don't think it's for the court to use a prophylactic of sorts and try to wrap him up now. What we've seen, though, and Jane referenced the travel ban, I think it's a very good discussion written, more than I wish to care about the travel ban. The lower courts have gone gangbusters, to use Andy's phrase. They've done stuff that is just stunning. And on 2 occasions, the Supreme Court has narrowed them. Narrowed, right? Not rebuked, but narrowed. And the court has narrowed them. Jack Goldsmith, who teaches at Harvard, has used the phrase of lowering the temperature. So at least I think there's some adults left in the room in the judiciary and the Supreme Court. They've been able to at least calm things down. My one word of caution is we're only in, month 7, month 8 of this presidency. We don't know what the heck comes down, right? And you know, some of my college law students are in the room, but we'll talk about, can the president be prosecuted in criminal court? Can the president be indicted, right? These sorts of questions about emoluments are trivial, right? I mean, they're fun, but they're secondary. What happens if Bob Mueller recommends that Donald Trump be indicted? What if he seeks an indictment himself? I don't think he can, but you know, assuming he could. What if Congress passes another special counsel statute? They won't, but let's say they could. Let's say we have an impeachment process. We try to remove the president over emoluments. And me and Seth will have to go testify in his defense. You think about that yet? I have. You know, it's a weird space we're in. And I wasn't around during the Nixon era, but I've talked to people who were. They say it has a very similar vibe. And again, Nixon was after a re-election, things kind of blew up. We're in like month 6 or 7. So I don't know where this leads, but I will keep telling people to stop, slow down, think of what you're doing. And then if we remove him, we remove him. But there's a significant cost to doing this that you don't always appreciate in the heat of the moment. Does that want to add anything?
Sure. It's more impressionistic than anything else. There is naturally a desire to live in a better world and to make use of the levers of power and government that we have access to get to that better world. But there's also a feeling, a view, a long-term view that you use established procedures and precedents, and that you're governed by, or hope to be governed by, a rule of law society. And as a matter of fact, to just slightly get into something a little political, I try not to do, whether you agree with him or not, or whether you agree with the people who elected him or not, I happen to believe that a large reason many people, certainly not a majority, who voted for Donald Trump, was they see a deterioration of the rule of law in this country. They're afraid of the exercise of discretion, and that includes the exercise of judicial discretion as one element of that. They see it as lawlessness, often lawlessness by people in robes who cannot be criticized, at least ought not to be criticized, or at least we're sometimes told they ought not to be criticized. And what I hear from certain people, and to some extent I've heard some of it today, is that because these consequences are so bad, we have to rethink about things we've never thought about, or rethink about things we thought about in a new way, to play a sort of let's pretend that things mean what no one ever thought they meant. There's one professor from Georgetown who has scoured dictionaries, perhaps you've heard of this too, to prove that emoluments means a particular thing. Scoured dictionaries. We have 500 years of case law, not just in the United States and the federal and state system, I'm going broader than the United States, across the English-speaking and common law world. He can't find one case of any court of record that says an emolument means what he thinks it means, so he's gone to dictionaries. All right? Now, you're getting in very dangerous ground at some point when the rule of law will disappear. Right? And that's the way it's going to be seen. If you pretend something means something no court of record has ever come close to asserting. Right? So earlier I heard that, Jane put forward the idea, something along the lines she said, I find it difficult to believe that the framers didn't see it this way or didn't provide for this particular situation. I think that was the way she put it. She'll correct me if I'm wrong. And that could be understood in several different ways. Some of them are more positive than the others. But one way it could be understood is, aren't those framers in line with my moral intuitions? Right? I mean, that's a stunning assertion if that's what was meant. The framers are in line with my thinking, as opposed to our investigating what they were thinking and admitting that we don't know. Right? That's a very dangerous ground to say, the way I'm going to understand the past is by what I think now is a good consequence. In part because many people today disagree with what makes for good consequences. And that's why we have elections, because we have those disagreements. And to project our particular politics or moral feelings onto the framers is to have the rule of law just disappear.
Jane, I assume you want to respond?
My only reaction to that is there's actually not that much daylight between Seth and me in the sense that a lot of Seth's argument relies on the assertion that the framers were really honorable, and clearly that reflects what he considers to be honorable. My assertion is that the framers are really smart. And I think that given the interbranch dynamics that I described and the ways in which presumption of regularity actually is contingent on the nature of the executive's conduct, I am merely saying that I think the framers would have thought about this, and if they had thought about it, I think this is what the emoluments clause means. So I'm not necessarily saying the framers thought what I think. I'm merely saying that given these interbranch dynamics, the framers probably considered it. There's other evidence that they were very careful. As Professor Teachout explained, there's a lot of anti-corruption focus in the Constitution, and I think that carries through in the emoluments clauses.
Maybe I'll turn to standing. We talked a lot about these court cases coming, but I don't know whether we actually will see any of these cases resolved. I don't know, you guys learned about standing. For me, it's one of those areas where every time you read a new case, you just end up more confused than where you started. So I'm not going to try to explain standing here. Maybe we can talk about perhaps, I think, the easiest case for standing, and that relates to the lawsuit between 200 members of Congress against President Trump. Now, the Supreme Court has never, ever blessed federal legislators suing the president. There's been some funny cases dealing with state legislatures. And maybe Josh, you know a lot about standing. Can you maybe assess that?
I have to stand up. I mean, so
How many did you hear any of these cases actually?
one of the aspects of what I broadly dubbed the legal resistance is trying to, giving a keynote at Faulkner Law Review
next month. The title's going to be The Legal Resistance, so stay tuned. So one of the attributes of the legal resistance has been the recognition that we lost the election, so let's go to the courts and get some relief in. And that's nothing new. Texas did that for years. I was very much involved with the US v. Texas litigation, which involved DAPA. And Texas asserted that it had standing, and argued that it had standing as a state because the DAPA beneficiaries would get driver's license, incurred fees, and the state paid those fees. I actually thought that was a good application with or without match to EPA. The arguments here, though, are different, right? So, for example, CREW, one of the organizations that filed suit, Zephyr is one of their lawyers, they argue that the group has standing, follow me here, the group has standing because they diverted resources to investigate Donald Trump's corruption. That is, had Donald Trump not been elected, they would have done something else with their time and money. But because Donald Trump was elected, they had to redirect their assets to investigating Trump's finances so they could bring the lawsuit against him. Now, some of you are laughing. Maybe you shouldn't. I don't know. It might get accepted. I argue this is a self-inflicted injury, right? It's like, stop hitting yourself. Stop hitting yourself, right? If you don't want to spend resources suing Donald Trump, don't sue Donald Trump. But that doesn't get you to federal court. Now, they've since added other plaintiffs to their case. Seth, you want to talk about the other plaintiffs?
Yeah.
Yeah. I cut him off before because I don't have time, but you can talk about the plaintiffs.
I'll briefly talk about it. So let me say, by way of introduction, that I'm not affirming that anything you're about to hear is true. You're going to have to reach your own judgment on the real state of the facts. In the CREW litigation, there's one plaintiff named Eric Good, and the complaint says Eric Good has standing because he owns multiple hotels and multiple restaurants in New York. Right? And the reason he has standing is because his restaurants and hotels are in competition with Trump entities, and therefore he faces a competitive injury. Everybody see what the argument is here? There's a guy named Eric Good in New York. He owns hotels and restaurants, that's what the complaint says, and he suffers a competitive injury. I'm going to leave aside competitive injury. Do I have any people here who've studied tax law or company law, corporate law? Any people? Oh, Andy. Well, let me ask a student. Yes,
I was kidding.
All right, okay, good. Student, tax law. All right. If you read a document that said someone owned outright a bunch of restaurants and
Well, you would probably want to audit through some kind of corporate entity.
limited liability. Oh, yeah. The complaint doesn't say that these restaurants and hotels are owned by entities. It says Everett Good owns them outright. Now, God forbid I should say the complaint isn't true. I have not done any personal investigation to find that out.
Yeah.
But the complaint says he owns them outright. The New York Times actually mentions he has a business partner named Sean McPherson, but the complaint doesn't mention that. Because
Liquor license also, they say owns the hotels.
the reason this is important is if there is a competitive injury, the entity that has that injury is the entity, not the shareholder or the stockholder. There's law on that, very decided law about derivative standing. A stockholder can't step in the shoes for an injury of the entity. It's very basic law. But there's nothing in the complaint about that. Now, I'm not affirming that they lied in their complaint. I haven't investigated Mr. Everett Good. But I will say this, though, that if, in fact, there are lawyers representing Mr. Good who came to them with this case, right? He said, I've suffered injury. And if they haven't taken the time to advise him, by the way, Mr. Good, after we're telling Trump, you really should reorganize your business affairs because you're facing all sorts of tax and liability risks that happen. They're not very good attorneys. That poor guy. I mean, a lawyer is, this is the way I learned about the way to describe the relationship between a lawyer and his client. A lawyer is a special friend. And if the lawyers for Mr. Good, in the context of this litigation against the president, as a special friend, have to take the time to say, if you really are the owner you claim to be, right, that if you really own all these hotels and restaurants outright, we ought to clean up your business, relationships to get you the protection you deserve. Because to tell you the truth, when I read that complaint, I'm really wondering. And now they have another complainant in that action, a woman named Jill Fanoff. And a very interesting woman in the complaint, what it says about her. Am I going on too long about this?
A little bit.
All right, well, it's interesting. I think the audience is liking it. The complaint about Ms. Fanoff, why is she in this litigation? She is a scheduler, according to the complaint. She's a scheduler. That is, what she does is she arranges for all sorts of functions and business and commercial entities to have events in hotels. And to the extent that business is being taken to the Trump hotel, it's not coming to the hotel she works for, and she's not getting her commission. And that's a real powerful claim. It really socks home if it's true. So Google Jill Fanoff, and you'll see she pops up on a website of a hedge fund as an employee, as a full-time employee, it looks like. Now, I'm not saying she doesn't do scheduling on the side. Outside of being an employee of a hedge fund, maybe she does both, and maybe the complaint is exactly what it says. But if she's a full-time employee of a hedge fund and she isn't really a scheduler, then she can't claim standing for losing commissions in the future. And you really gotta wonder a little bit about this complaint. Now, I'm not saying she's not the scheduler. She complains. I haven't watched her house. I don't have a line into her computer that I can see what she's been doing for the last while. But you're going to have to decide for yourself whether the claims in the complaint pass the believability test. Because, it wouldn't be nice for me to say people are lying.
Jane, I want to press you on something that we've disagreed on. I don't want to get too deeply into the weeds. Hopefully I'll make the question general enough. Question/argument. I think Jane and I read OLC opinions and comptroller general opinions differently. Although I think what we would both agree on is that you pick up an opinion and you will find language saying that we must consider the purpose of the Foreign Emoluments Clause that's designed to prohibit corruption of any sort, to quote Randolph and things of that sort. And so you will certainly, without a doubt, find language like that, paragraphs sometimes extensive. And in those same opinions, they will say, all right, well, let's turn to the text of the clause. For example, the Reagan opinion, first they consider the purpose, then they consider, all right, what's the legal definition? My presentation, I said that every definition and every opinion adopts this officer-related compensation model. Absolutely acknowledge that in those opinions, they, without a doubt, they can do it on purpose. And I think it's perfectly fair to say that the right way to interpret the clause is with reference to a purpose that is corrupting it. I don't agree with that, but I think it's completely fair to make that argument. My general question is that question, maybe what we're debating on, the text versus the purpose, is that something that any court would give credence to? I would think that a court isn't going to defer to the OLC that when we interpret this provision, we're going to adopt a purpose-based argument or a text-based argument. And to that end, I think that a court would give way to a definition reached, but it would not say that because OLC has adopted a living constitution approach or purpose approach, that it would say, all right, we should defer to that method of interpretation. Because courts historically, I think the methods of interpretation are a core part of the judicial power. Do you disagree? Anything I suggested?
So I don't think the assertion is that the courts ever blindly defer to the OLC. I think the reason to rely on OLC opinions is underlying that kind of reliance is recognition that the OLC occupies a very special place within the interbranch structure. Some have described the OLC's position as quasi-judicial within the executive branch, in part because the OLC will often address issues that, for whatever reason, the courts might not even have a chance to address in depth. So, for example, the Foreign Emoluments Clause, we haven't seen litigation on the Foreign Emoluments Clause in the courts, and that's why the OLC opinions on the Foreign Emoluments Clause, why those opinions are so valuable. It turns out we do have this store of interpretation. And so, again, I don't think the courts will blindly defer to it. I think that it will recognize that the OLC has interpreted the clause in a way that the courts haven't had a chance to. And so it's just a body of I think, persuasive evidence as to how perhaps the clauses should be read.
That's fair. Seth, the risk of asking you another question. Seth, there's this very inscrutable case called Burton v. United States. I'll tell you a little bit about it before asking Seth in his papers will say it's inscrutable. Nobody knows exactly what it means. I'm going to try to force him to tell me what it means. What happened in Burton is that a sitting U.S. senator was convicted of a crime. The think he took money to help somebody in front of an agency. And as part of the conviction, the sentence appropriately, he was prohibited from holding any office of profit or trust or honor under the government of the United States. So language similar to the Foreign Emoluments Clause. It's a little bit different. It refers to profit, trust, and honor, and it says under the government of the United States as opposed to under the United States. And this case went all the way to the Supreme Court, and he says, how can this statute be constitutional? The Constitution says that the Senate can expel me. This statute is saying that I'm going to get expelled, that I can't hold an office of profit, trust, or honor under the government of the United States. The Supreme Court says, well, actually, the statute doesn't pose a constitutional problem. You're a senator. You're elected by the people as a precursor to the establishment of the United States. You are not under the government of the United States. Now, depending on what you make of this additional government language, for argument's sake, I'll say it doesn't matter, even though I know that there's different constitutional provisions that address it differently. I think that case, arguably, if you view government of the under the government of the United States the same as under the United States, I think it's very strong evidence of your position. On the other hand, if you attach weight to this additional language regarding government, it may cut the other way. And it's a very weird case, but it uses language which is obviously modeled after the Foreign Emoluments Clause. And they add the word honor, they refer to the word government of the United States. Sometimes the Constitution refers to the United States, sometimes it refers to government of the United States, whether that's meaningful or not. Seth and Kilamara, different interpretations. But I don't think it can be ignored in the analysis, even if it's inscrutable. So how would that qualifier limit anything you view regarding whether the president is covered?
What do you mean covered by that statute?
Oh, by the Foreign Emoluments.
Well,
under the statute, obviously,
right,
that would be
right.
an easy question.
Well, let's do the easy one first. There's the statute. Many statutes, including statutes that go back to the very first Congress, pose disqualifications on people who've been convicted of crimes. All right? And sometimes those statutes reflect the language that's in the Foreign Emoluments Clause. And this statute that Professor Gruhl is talking about is a much later statute. And it uses language that is akin to the language in the Foreign Emoluments Clause. And it says, if you've been convicted, you are disqualified from holding an office of honor, profit, or trust under the government of the United States. And the way the Supreme Court explained that language applied to appointed office. It didn't apply to elected offices such as the senator, such as being in the Senate. And I would think by extension, that statute couldn't apply to the president. So there's really two questions there. If Congress intended for that statute to apply to the president, would it be constitutional? Or should we assume they never intended it to apply because it would be unconstitutional? And I happen to think the latter view is the better view. That is, Congress couldn't have intended that statute to reach the president because Congress can't create the qualifications or disqualifications for people who run for president. The Constitution lays out all the qualifications. That said, I don't think it really advances my case because the language is different enough that people could assert under the government of the United States is a more limited category than under the United States, and perhaps the president is in the larger category rather than in the narrower one. I mean, I don't mind saying that there is a lot of persuasive evidence over the years that I have rejected putting in my papers because there is an obvious counter-argument, and I like to put in my papers things that I think are the strong arguments rather than to have back and forths over things that I just don't think get us really towards an answer. That's why I've always been so attracted in part to a few of the stronger arguments, including the ones related to the Hamilton documents, which may very well be litigated very soon in the Southern District of New York. As odd as it sounds, I mean, that a document from 1790 signed by the Secretary of the Treasury, 1793 actually, might matter in litigation.
Have you emailed Lynn Miranda about this document?
Or is she from the play?
I have a lyric.
Okay.
He's going to sing for us now. So.
It must be nice. It must be nice to have George Washington on your side. It must be nice. It must be nice to have Alexander Hamilton on your side. That was an early draft of the brief that cut out. It didn't fit, but you now have my poetic license.
Really?
Oh, yeah.
Oh, later lyrics did not fit in your brief, I'm sure.
Wait, can I ask a question?
Absolutely, please.
My key, was I off key?
No, you're great. Seth, you started talking about the Hamilton, the letters, and right now I understand there's this controversy about a second Hamilton letter. Could you?
No, they're not letters, they're reports or copies of reports.
And I'll say for that one, stay tuned.
Okay, so there's more coming.
Yeah, I got a little bird told me some interesting stuff about those letters.
So stay tuned. As counsel, as I was going to stay tuned.
Okay. They're involved in that.
Stay tuned.
Anyway, stay tuned. The questions from the audience before I go.
Before you go on. Jane, I'll just add one word that I put in before. If the plaintiffs really believe the things they're saying about me, then a civil procedure professor would, or an ethics professor would tell them what to do, because you're hearing it now from me. I'm not retracting anything. All right? So if they're waiting for me to retract, it ain't happening. Answer.
Sorry, just to be clear, our this is a separate question.
Okay.
Senators and representatives, you say, are not in offices under the United States? Is that right?
Offices under the United States extends to appointed officers in all three branches. It would include elected members of Congress.
And just a little bit more law on this. In 2009, the Obama administration issued a memo saying that the president was surely covered by the Foreign Emoluments Clause. And virtually every other opinion, aside from the Reagan, Bush, and a little bit on the Clinton administration, we've said over and over again that the Appointments Clause and the Foreign Emoluments Clause are coterminous. That is, officers who are appointed and confirmed by the Senate. After the Obama memo, which just one word said the president is covered, in the Obama administration, subsequent opinion written by the now First Circuit judge said that no, it's just appointed officers. So there's a real question, and I suppose I don't know the answer. I'm sympathetic to Seth's arguments, but I just haven't studied it closely enough to see that I disagree with Zephyr. It is a real question. I think for everything you've heard today, you should not walk out of this room with a firm agreement or disagreement with anyone. You really have to sit down and read it. It's not, these aren't issues that you can really form a strong understanding of without spending the time. I spent months just researching and reading the article. And I have no doubt that other folks here have spent a lot of time forming their thoughts. My last question relates to, let's say that, let's assume, rightly or wrongly, that the Foreign Emoluments Clause does not apply to the president. Disagree on that. Could Congress, and I think this folds into the president's special place under the Constitution, could Congress pass ethical statutes restricting the president? To some extent, they already do. The Foreign Gifts Act says that if you go to China and get a gold watch from the minister or president, or whatever they're called, you have to deposit it with the State Department. But could Congress say, well, you know what? If you run a hotel business, you cannot negotiate with any country in which you have a hotel. You are recused from matters involving any place where you have substantial business contacts. I know my view on it, but I'd like to hear some more views, and this may inform the general question of whether it's appropriate or really realistic to impose ethical restrictions on this special federal official. Josh, you want to kick it off, and then Jane maybe respond?
Well, I had this part in our first brief in the Southern District of New York, and I probably shouldn't have written it, but I did. And I'll read it to you. In our constitutional order, the president holds a special status. The president generally cannot be sued for actions that arise in his official capacity, almost certainly can't be subject to a criminal trial, and arguably can pardon himself. I wrote this back before it was an issue. It became an issue subsequent. As Chief Justice Marshall explained in the case of United States versus Burr, that is Aaron Burr, the guy who shot Hamilton, Marshall wrote, in no case of this kind would a court be required to proceed against the president as against an ordinary individual. Indeed, a couple of years ago, in the Zivotofsky case, the court said, pursuant to some unenumerated recognition power, the president can even disregard an act of Congress to maintain government interests. This perhaps responds to Jane.
Is it unthinkable that the framers permitted the president to accept foreign gifts, perhaps to support his enumerated power to receive ambassadors, without first having to seek consent of a particularly hostile and slow-moving Congress? The Constitution affords the president some potentially self-aggrandizing discretion. The Republic is better off if he does not use it, but if he does, it's no constitutional violation. And I'm reading from our brief, so this is nothing new, but he holds a unique position in our government, especially in matters of foreign affairs. I tend to think that the framers thought about it. They were okay with the president having the ability to accept gifts without first having to beg Congress permission. You can imagine a situation where the king of some country wants to send the president a gift, and the Congress hates him and say no. And then the foreign king is insulted, and he launches a war. I mean, you don't know what a diplomatic gift is by today's standards. Wars are fought over lack of proper decorum between the nations, right? An armada didn't show up at our shores because Congress didn't allow the president to get a gift. I'm comfortable with this, right? I don't think it's insane. I think it's even far less ambitious than if he has like Zivotofsky, where the president basically wrote a statute.
So Jane, if it is the case that the president isn't in fact covered and you were the Queen of Congress and you can make them do whatever you want, the legislative power was vested in James John. What statutes do you think could constitutionally be passed? We've seen proposals by Adam Schiff to, for example, ban payments from the Secret Service for the use of golf carts at Trump properties. What's your view on what could constitutionally be done to address this conflict of interest if the Foreign Emoluments Clause is the answer?
I think it depends on the nature of the statute. If Congress decided to pass a statute that said that the president must liquidate in the case of branded properties, such as the ones Trump has, or to turn over his businesses to a blind trust, which would work in the case of most people who are not Trump, I think that would be constitutional. Could Congress pass a statute that says that the president cannot fulfill his executive duties in countries where he has financial interests? That would be a lot more touch and go. You're literally saying that the president cannot be the president with respect to certain kinds of foreign policy decisions, which I think is very strange. Why wouldn't you, as a Congress, simply force the president to liquidate?
You wouldn't feel that adds to the qualifications of being president, 35 years old, natural born citizen, and own no businesses?
I mean, it depends on how you word it. If you say that somebody who holds the office cannot have certain kinds of conflicts, I imagine you can word it in such a way that it's not a qualification.
We're out of time.
One more, yeah, it's fine. I will cede my closing remarks time for Seth to the last word.
It strikes me that one of the reasons we have restrictions on appointed officials like cabinet members and civil servants is they're full-time positions, right? You're in the civil service, you have it, you hope for life. It's fair for Congress to tell you restrictions on your personal activities. The people get to elect a president for 4 years. If Congress gets to pick and choose what sort of private finances the presidents have, then it's basically telling the people, we can make sure you pick right. So when Congress creates statutes that have the ability to reward or punish presidents for how they engage in their private affairs, to be perfectly blunt, it's taking your vote away. And that's what it amounts to. So it's not a qualification. It's just robbing you blind.
So just to be clear, Seth, you're saying that the Foreign Emoluments Clause does not apply to the president. And moreover, if Congress wanted to get rid of the conflicts presented by Trump's businesses, it would have to pass nothing short of an amendment.
No, I didn't say that at all. What I said is such a statute would be a terrible, terrible imposition on the voters of this country. Would it be constitutional? Maybe. But it would be an awful statute. It would be robbing you blind.
Can the Supreme Court impose ethics rules in the Supreme Court? Oh, so Chief Justice Roberts, up close here, I'm sorry, Seth. A couple years ago, the Chief Justice issues a report every year on December 31st. It's my favorite time of year. It's always on New Year's Eve, either at 5 or 6 p.m., depending when you release it. And some years ago, there was a discussion that Congress could pass a statute requiring Supreme Court justices to recuse in certain cases. Now, lower court judges, they're called inferior for a reason. They are subject to ethics rules. Congress can legislate that because Congress can create the inferior courts. The Supreme Court is created by Article 3, Section 1. It's created by the Constitution. And Roberts issued, I think, is an advisory opinion, which is right. He said, that Congress can't legislate on the court because Congress didn't create it. I think that's right. Congress didn't create the president either. They can't legislate him. Congress can legislate itself under the Rules of Proceedings Clause. They have unicameral autonomy. They can make their own rules, which is fine. But they can't control the president. They can't control the courts. Thank you very much.
And I think now I may close remarks very brief. I am on absolute cloud 9. I love teaching, I love speaking, I love education, I love the exchange of ideas. And if you notice, no one came to blows. Seth came close. But no one came to blows. There was no vitriol, there was no hatred, there was no loving room. We've discussed today a very contentious issue, and all of you are going to be so informed when these cases are argued in the next couple of months. You may see me there. And as this case goes up, you're going to be so well to understand the issues presented here. And I promise you this issue of the South Texas Law Review will be cited well and give to judges knowledge that they otherwise would not have. And I think that's what law school builds. You don't realize as a law student what you are. You are another cog in this long tradition. There's this great expression, which was not from Newton, but attributed to him. If I can see forward standing on the shoulders of giants. He didn't actually make it up, but it's often attributed to Newton. And all of you are standing on the shoulders of people who came before you, people who came before them. I'm your teacher, I'm my teacher, they're their teachers, and this is the continuity of the law, this slow accretion, not avulsion, of how we develop our traditions, and this is yet another building block, fundamental block in that process. Thank you all so much. I'll be around afterwards if you have any questions. Kudos to Fanny and Adam, and I adjourn this conference. Thank you very much.